Hello, ladies and gentlemen. This is your captain speaking, Brandon Joe Williams, one stupid fuck. Website is www.myfaceisachair.com. I was thinking today, I was like, I do all this research all the time, and I never do videos about it until it's done and this kind of that. And I thought, you know what, hell, I'm going to start a new little segment, and if you guys like it, I'll keep doing these, maybe, if I feel like it. It's going to be called Research with Brandon. And this one here is entitled, Are U.S. citizens and illegal aliens basically in the same classification? That's going to be the name of this video, and put some comments down in the comments. Let me know what you guys think. If you guys like it, we'll do more. It's definitely going to be different than a lot of what I've done before. It's going to be kind of, all over the place and kind of goofy and stuff like that, because it's not. These videos might be me going into areas that I'm not super familiar with, or you guys can kind of see how my research goes and how I kind of roll with these kind of things. So if you like it, let me know. Hit the like button. Leave me a comment. Let me know what you think. If you're not so fond of it, let me know, and I'll stick to just the later videos once I've got it all figured out, and I just bring it to you guys on the silver platter. So here we go. Let's get a little screen share action going, and I'll show you kind of where we're at and what I'm doing, right? So there was some comments recently, I don't remember where they were, on Facebook, talking about illegal aliens, and I was like, there really isn't such a thing as an illegal alien, really, if you think about it. And I got some flack for that. So this video is kind of based on that, right? So I asked, so I have Super Grok. I pay for the upgraded Grok because I just paid for whatever the biggest X upgrade I could pay for. It was like $50 a month or something. I was like, yeah, sure, whatever. So I have Super Grok. I don't know how different it is than the normal Grok, but I think it's a lot different. So I asked Super Grok, what case is it that showed that illegal aliens have rights under the 14th Amendment? And it gives me this Plier v. Doe, right? And it gives me a little bit of a overall background of what it is, right? And then, what I wanted to ask it next is, has Plier v. Doe ever been overturned? And it says no. And it says, in fact, it's been cited approvingly in a couple other cases later, right? It's never passed a law overriding Plier, though bills have been proposed, right? So just real quick about AI in general, a lot of you guys use AI to like, is this true, or what if I did this, or what if I did that? I don't think you should use it for that. I mean, I spend so much time just blocking people who post that kind of trash on because I'm not going to spend all the time required to fix all of it and clean it all up and handle. I'm just going to block, literally, with no warning. It just pisses me off. It's like, you're not going to dump a burning pile of shit in the middle of my comment section and think you're going to get away with it. So, they wind up logging in or looking for that comment, and they notice that it's gone, and then they notice they can't pull up my profile, and we're all happy. I'm happy. They're not happy, which makes me happy. Everyone's happy. And that's basically how it goes down all day long, every single day, right? So the correct way, or the better way to use AI, is to ask it to either locate things for you or historical information. Absolutely fantastic. I didn't use AI a lot for my book. I used it a little bit. Maybe even more than a little bit. Maybe a upper low or low medium amount was actually done to build out the book, right? Because all the historical stuff and all that kind of stuff, right? So these kinds of questions are the way I would do it, because, when I'm getting these answers, there's a very low chance that a lot of the stuff is probably false. I mean, I don't typically double check this kind of stuff. If it's historical, or if it's, hey, find me something, I'm not really going to freak out and necessarily double check everything. Now, if I was going to file this into a lawsuit, you bet your ass I'm going to go through here and double check all of this, which I have done in all my cases previously. But most of the time and for videos and stuff like that, I'll just take, unless I see anything that's like wildly out of the ordinary. And then the next question I had here is, before 1860, was deportation in America really a thing? Negroes did not have citizenship, so they had no legal protection or ability to operate in the courts. But were they just left to be around here, just left to be here without deportation? Please explain to me the timeline of how things were handled back then if someone did not have citizenship. And this is all based off of the case, Plyer v. Doe. Here's the docket, the final opinion from the Supreme Court. I will put a link to this docket down in the video description for the video on YouTube. Right away, we see here the question presented by these cases is whether, consistent with the Equal Protection Clause of the 14th Amendment, Texas may deny to undocumented school-age children the free public education that it provides to children who are citizens of the United States or legally admitted aliens. Now, let's stop for a second. So first and foremost, we have these various 14th Amendment related items. Item number 1 is a citizen of the United States. Item number 2 is legally admitted aliens, whether that be they are naturalized or they're naturalizing or whatever it is, right? Green card holders, right? So it's interesting because obviously state citizenship isn't mentioned here, obviously, right? Because it's all under the 14th Amendment, so that would have nothing to do with state citizens, right? This next section here, since the late 19th century, the United States has restricted immigration into this country. Now that set me off right away, because I was like, well, what about before the late 19th century, right? And that's where this question came from. Before 1860, did they deport, right? I haven't even looked at this yet. I want to just start the video and then kind of go through this with you guys. Before 1860, formal federal deportation, as in the centralized government system for removing non-citizens from the country, did not exist in the United States in the way that it is today. Immigration and removal policies were largely handled at the state and local levels. That makes sense because it was state citizenship. Evolving from colonial-era poor laws that allowed authorities to expel undesirables like paupers or criminals to prevent them from becoming public burdens. These practices were inconsistent, often discriminatory, and targeted specific groups based on economic, racial, or nativist concerns. Nativist. Being native born, probably to that state, something like that. Okay. Non-citizens, including the free black people that were denied citizenship right as affirmed by Dred Scott versus Sanford, had limited protections and could not fully access courts or due process. However, black people were not typically subjected to overseas deportation en masse. Instead, they faced internal restrictions, state-level expulsions, re-enslavement threats, and voluntary but often coerced colonization efforts. Below, I'll outline a timeline of how non-citizens were handled with the focus on the antebellum period. The hell? Antebellum. The period in American history before the Civil War. Oh. There's actually a word for that. Interesting. Antebellum. I had no idea. Colonial roots. English Poor Laws, which empowered local officials to warn out or remove indigent people, citizens or not, to other towns or colonies, if they might rely on public aid. This wasn't formal deportation, but expulsion to shift burdens elsewhere. Enslaved black people brought involuntarily via the slave trade were treated as chattel property with no rights or citizenship claims. Free black people, a small minority, often released from slavery or descended from indentured servants, had some limited freedoms but were subject to discriminatory laws. Post-independence, the U.S. Constitution gave Congress power over naturalization, but it did not explicit control over immigration or deportation until later interpretations. States retained authority over internal matters. The 1798 Alien and Sedition Acts marked an early federal foray, allowing the president to deport non-citizens deemed dangerous during wartime tensions with France. But that expired in 1801 and was rarely enforced. Non-citizens, mostly European immigrants, could be expelled by states if seen as threats or paupers. For black people, the 1790 Naturalization Act limited citizenship to free white persons, explicitly excluding them. Free blacks on the North and the South faced black laws or codes restricting movement, assembly. Okay. This era saw, this is 1800 to 1860. This era saw rising immigration from Europe, prompting more structured removal efforts. Deportation remained state-driven, not federal, and was patchwork. No comprehensive national system existed until the 1880s, starting with the Chinese Exclusion Act. Okay. Paupers. They did not like those. Okay. Interesting. Were the deportations that occurred on the state level typically deporting them out of just that specific state or the United States entirely? Yeah, that's what I figured. State level deportations before 1860 were almost always expulsions of that specific state only, not out of the United States as a whole. That's what I figured. Interesting. So it was like the European Union, which is exactly how we're supposed to be operating. Very interesting. Unsanctioned entry into the United States is a crime, and it references this 8 USC 1325. Let's take a look at that. Improper entry by an alien. An alien who enters or attempts to enter the United States at any time. What's the definition of United States? It means the continental United States, Alaska, Hawaii, Puerto Rico, Guam, the Virgin Islands of the United States, and the Commonwealth of the Northern Mariana Islands. Well, first and foremost, why is Alaska and Hawaii here? Because those are made into states. And why are these, what does this mean? What does continental United States mean? Yeah, it's just, always something to look at. You know what I mean? At any time or place other than as designated by immigration officers or eludes examination or inspection by immigration officers or attempts. Let's take a look at this here. Okay. Attempts to enter or obtain entry to the United States by willful, false, or misleading representation or by the willful concealment of a material fact. An alien who is apprehended while entering or attempting to enter the United States at a time or place other than as designated by the immigration officers shall be subject to a civil penalty of $50 to $250. No wonder there's so many people trying so hard to get into the country. Look at that. 50 to 2. What are you going to do? If I don't pay and you kick me out, there's really no. What do you? If I have cash on me in my wallet, I guess you get paid. If not, I guess you get nothing, huh? Marriage is 10 times, a million times worse. Look at that. 250 grand if you get married illegally to do that. Any individual who knowingly establishes a commercial enterprise for the purpose of evading any provision of the immigration laws. That's hilarious. A corporation is a person, so that's just ridiculous. That's just totally circular and ridiculous. Okay. And then here's deportation. Let's take a look. Transferred. Well, shit. Let's go to the notes section and see what we got for transferred. Right here, it looks like deportable aliens. Good. We found the transferred item here by going to the notes. Let's take a look. Deportable aliens. Definition of an alien. Not a citizen or national of the United States. That comes from 8 U.S.C. 1101. Violators of conditions of entry. Marriage fraud. Moral turpitude? What the hell? Wickedness, depravity. Okay. Any alien who is convicted of a crime involving moral turpitude committed within 5 years. Interesting. Multiple criminal convictions, high-speed flight. Aggravated felony, failure to register as a sex offender, waiver authorized. Controlled substances. Stalking, violence. Trafficking. Okay, these are all like deportable type stuff. In May 1975, the Texas legislature revised its education laws to withhold from local school districts any state funds for the education of children who were not, quote, legally admitted, end quote, into the United States. The 1975 revision also authorized local school districts to deny enrollment to their public schools to children not legally admitted, quote unquote, to the country. So we have class action. This is a class action from Texas from 1977. So it took 5 years to get all the way to the Supreme Court and through the Supreme Court. Mexican school-age children who did not establish being legally admitted to the United States. The action complained of the exclusion of plaintiff children from the public schools of the district. Residing, look at that. After clarifying a class consisting of all undocumented school-aged children, after certifying a class residing within the school district, the district court preliminarily enjoined defendants from denying a free education to members of the plaintiff case. The superintendent and members of the board of trustees of the school district was named as defendants. Okay. In December 1977, the court concluded an extensive hearing on plaintiff's motion for permanent injunctive relief. Um, the court found that neither the section nor the school district policy implementing it had either the purpose or effect of keeping illegal aliens out of the state of Texas. Saying it was involving something else. The court noted that under current laws and practice, quote, the illegal alien of today may well be the legal alien of tomorrow. And that without an education, these undocumented children, already disadvantaged as a result of poverty, lack of English-speaking ability, and undeniable racial prejudices, will become permanently locked into the lowest socioeconomic class. Interesting. That's liberal as fuck. The district court held that illegal aliens were entitled to the protection of the Equal Protection Clause, the district court said, of the 14th Amendment. Okay, let's take a look at that. I need to take a look at the Equal Protection Clause. Let's take a look at that. Mm-hmm. 14th Amendment, let's see here, Equal Protection Clause. Meaning of person in the Equal Protection Clause. Let's take a look at that. Okay, are we having some troubles here? Meaning of within, wait, what? What is happening here? In the case in which it was first called upon to interpret this clause, the court doubted whether this provision could apply to state actions that were not directed at newly freed slaves, arguing this amendment was clearly a provision for that race. Yeah, okay, good. It sounds like, honestly, it's finally some honesty here. And intended to remedy discriminatory laws directed at freed slaves. Nonetheless, in deciding the Granger cases shortly thereafter, the justices, as with the Due Process Clause, seemingly entertained no doubt that the railroad corporations were entitled to invoke the protection of this clause, meaning legal fictions. 9 years later, Chief Justice Mr. Waite announced from the bench that the court would not hear argument on the question whether the Equal Protection Clause applied to corporation. Okay, that's Southern Pacific Railroad Company versus whatever, 1886. The word has been given the broadest possible meaning. These provisions are universal in their application to all persons. What the fuck? This is like literally telling us that there's only two classes that the word person is defined as. It's the newly freed Negro slaves and legal fictions. What is going on? What is going on here, dude? Unbelievable. Still looking for the Equal Protection Clause here. Let's go back. Let's take a look here. No state shall deny to any person within its jurisdiction the equal protection of the laws. Let's see. The first section. Let's see here. What the hell is this? Meaning of within its jurisdiction. Interesting. Belong to the citizens of the states as such. Incorporation of Bill of Rights. Man, we're just hitting all sorts of interesting things here. What is this? Interesting. Okay, well, anyways. The district court held that illegal aliens were entitled to the protection of the Equal Protection Clause of the 14th Amendment, and that this particular section violated that clause, suggesting that the state's exclusion of undocumented children from its public schools may well be the type of invidiously motivated, hateful, resentful, or unfairly discriminatory state action for which the suspect classification doctrine was designed. The court held that it was unnecessary to decide whether the statute would survive a strict scrutiny analysis because, in any event, the discrimination embodied in the statute was not supported by a rational basis. The Court of Appeals for the Fifth Circuit upheld the district court's injunction. The Court of Appeals held that the district court had erred in finding the Texas statute preempted by federal law with respect to equal protection. However, the Court of Appeals affirmed in all essential respects the analysis of the district court, concluding that this section was constitutionally infirm regardless of whether it was tested using the mere rational basis. Okay. The 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Appellants argue at the outset that undocumented aliens, because of their immigration status, are not persons within the jurisdiction of the state of Texas, and that they therefore have no right to the equal protection of Texas law. We reject this argument. Whatever his status under the immigration laws, an alien is surely a person in any ordinary sense of that term. Aliens, even aliens whose presence in this country is unlawful, have been recognized as persons, have long been recognized as persons, guaranteed due process of the law by the 5th and 14th Amendments. Indeed, we have clearly held that the 5th Amendment protects aliens whose presence in this country is unlawful from invidious discrimination by the federal government. Appellants seek to distinguish our prior cases, emphasizing that the Equal Protection Clause directs the state to afford its protection to persons within its jurisdiction. while the due process clauses of the Fifth and 14th Amendments contain no such assertedly limiting phrase. In appellant's view, persons who have entered the United States illegally are not, quote, within the jurisdiction, end quote, of a state, even if they are present within a state's boundaries and subject to its laws. Neither our cases nor the logic of the 14th Amendment supports that constricting construction of the phrase within its jurisdiction. We have never suggested that the class of persons who might avail themselves of the equal protection guarantee is less than coextensive with that entitled to due process. To the contrary, we have recognized that both provisions were fashioned to protect an identical class of persons and to reach every exercise of state authority. The 14th Amendment of the Constitution is not confined to the protection of citizens. It says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. These provisions are universal in their application to all persons within the territorial jurisdiction, without regard to any differences of race, of color, of nationality, and the protection of the laws is a pledge of the protection of equal laws. Yik woe. In concluding that all persons within the territory of the United States, including aliens unlawfully present, may invoke the Fifth and Sixth Amendments to challenge actions of the federal government. We reasoned from the understanding that the 14th Amendment was designed to afford its protection to all within the boundaries of a state. Our cases applying the Equal Protection Clause reflect the same territorial theme. Manifestly, the obligation of the state to give the protection of equal laws can be performed only where its laws operate, that is, within its own jurisdiction. It is there that the equality of legal right must be maintained. That obligation is imposed by the Constitution upon the states severally as governmental entities. Manifestly, the obligation of the state to give the protection of equal laws can be performed only where its laws operate, that is, within its own jurisdiction. It is there that the equality of legal right must be maintained. That obligation is imposed by the Constitution upon the states severally as government entities, each responsible for its own laws, establishing the rights and duties of persons within its borders. There is simply no support for appellant's suggestion that due process is somehow of greater stature than equal protection and therefore available to a larger class of persons. To the contrary, each aspect of the 14th Amendment reflects an elementary limitation on state power to permit a state to employ the phrase within its jurisdiction in order to identify subclasses of persons whom it would define as beyond its jurisdiction, thereby relieving itself the obligation to assure that its laws are designed and applied equally to those persons would undermine the principal purpose for which the Equal Protection Clause was incorporated in the 14th Amendment. The Equal Protection Clause was intended to work nothing less than the abolition of all caste-based and invidious class-based legislation. That objective is fundamentally at odds with the power the state asserts here to classify persons subject to its laws as nonetheless accepted from its protection. Although the congressional debate concerning the first section of the 14th Amendment was limited, that debate clearly confirms that the understanding that the phrase within its jurisdiction was intended in a broad sense to offer the guarantee of equal protection for all within a state's boundaries and to all upon whom the state would impose the obligation of its laws. Indeed, it appears from those debates that Congress, by using the phrase person within its jurisdiction, sought especially to ensure that the equal protection of the laws were provided to the alien population. Representative Bingham reported to the House the draft resolution of the Joint Committee of 15 on Reconstruction. 2 days later, Bingham posed the following question in support of the resolution. Is it not essential to the unity of the people that the citizens of each state shall be entitled to the privileges and immunities of citizens in the several states? Is it not essential to the unity of the government and the unity of the people that all persons, whether citizens or strangers within this land, shall have equal protection in every state in this union in the rights of life and liberty and property? Senator Howard, also a member of the Joint Committee of 15 and the floor manager of the amendment in the Senate, was no less explicit about the broad objectives of the amendment and the intention to make its provisions applicable to all who may happen to be within the jurisdiction of a state. The last 2 clauses of the first section of the amendment disable a state from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, or property without due process of law, or from denying to him the equal protection of the laws of the state. This abolishes any person, whoever he may be, of life, liberty, and abolishes all class legislation in the United States and does away with injustice of subjecting one caste of persons to a code not applicable to another. It will, if adopted by the states, forever disable every one of them from passing laws. Use of the phrase within its jurisdiction thus does not detract from, but rather confirms the understanding that the protection of the 14th Amendment extends to anyone, citizen or stranger, who is subject to the laws of a state and reaches into every corner of a state's territory. That a person's initial entry into a state or into the United States was unlawful and that he may, for that reason, be expelled cannot negate the simple fact of his presence within the state's territorial perimeter. Given such presence, he is subject to the full range of obligations imposed by the state's civil and criminal laws. And until he leaves the jurisdiction, either voluntarily or involuntarily, in accordance with the Constitution and laws of the United States, he is entitled to the equal protection of the laws that a state may choose to establish. Now keep in mind, the name of this video was named as a U.S. citizen and an illegal alien. So check this out. Are the rights of a U.S. citizen under the 14th Amendment? Yes. So it's the same set of protections that an illegal alien has. And that's kind of what I'm trying to show you guys in this video, right? There is no such thing really as an illegal alien. There's really just 2 classes. There's 14th Amendment people, there's 14th Amendment persons, which is literally anyone who's here, U.S. citizen, naturalized alien, or quote-unquote illegal alien. It's all the same thing. It's all a 14th Amendment persons. And then you have the white citizens of a state. That's it. We can ask Rock, are non-citizen nationals of the United States under the 14th Amendment, or is it some other section? I don't know. Let's see what that does. Interesting. They're non-citizen nationals by statute, not by 14th Amendment citizens. Huh. Interesting. I didn't know that. So they wouldn't be, I guess there's three classes then. There's the white citizen of a state, there's the various types of 14th Amendment type situations, and then there's the non-citizen national. Well, let's see here. Are Indian tribes under the 14th Amendment or some other section? Subject to the jurisdiction thereof. They're considered domestic dependent nations. Interesting. So Indians are also kind of like a different category. Interesting. We would not be faithful to our obligation of the 14th Amendment if we applied so deferential a standard to every classification. The Equal Protection Clause was intended as a restriction on state legislative action inconsistent with elemental constitutional premises. Sheer incompatibility or lax enforcement of the laws barring entry into this country, coupled with the failure to establish an effective bar to the employment of undocumented aliens, has resulted in the creation of a substantial, quote, shadow population, end quote, of illegal migrants, numbering in the millions within our borders. The situation raises the specter ghost, something feared as possible unpleasant or dangerous occurrence. Probably that one. The situation raises the specter of a permanent cast of undocumented resident aliens, encouraged by some to remain here as a source of cheap labor, but nevertheless denied the benefits that our society makes available to citizens and lawful residents. The existence of such an underclass presents most difficult problems for a nation that prides itself on adherence to principles of equality under law. The children who are plaintiffs in these cases are special members of this underclass. Persuasive arguments support the view that a state may withhold its beneficence from those whose very presence within the United States is the product of their own unlawful conduct. These arguments do not apply with the same force to classifications imposing disabilities on the minor children of such illegal entrants. At the least, those who elect to enter our territory by stealth and in violation of our law should be prepared to bear the consequences, including but not limited to deportation. But the children of those illegal entrants are not comparably situated. Their, quote, parents have the ability to conform their conduct to societal norms, end quote, and presumably the ability to remove themselves from the state's jurisdiction. But the children who are plaintiffs in these cases can affect neither their parents' conduct nor their own status. Let's see here. Public education is not a right granted to individuals by the Constitution, but neither is it merely some governmental benefit indistinguishable from other forms of social welfare legislation. Both the importance of education in maintaining our basic institutions and the lasting impact of its deprivation on the life of the child mark the distinction. The American people have always regarded education and the acquisition of knowledge as matters of supreme importance. Okay. We are reluctant to impute. What does that mean? Represent something as being done, caused, possessed by someone. Attribute something to something, assign a value to something. Special constitutional sensitivity. If the state is to deny a discrete group of innocent children the free public education that it offers to other children residing within its borders, that denial must be justified by showing that it furthers some substantial state interest. No such showing was made here. Accordingly, the judgment of the Court of Appeals is, in each of these cases, is affirmed, meaning that they agree with the lower courts and the appeal court. And then below that we have these various side notes or justices talking about various things or why they concur. I don't see anything against concurring. Oh, Chief Justice with with 1, 2, 3 others that dissent. Interesting. Let's see what this is. Now, just so you guys know, dissenting opinions don't really matter. It's whatever the, like anything below where it says affirm, when it starts getting into these are like just like comments. The thing was affirmed. That was it. That's the end of the story. But if anybody wants to say anything more or say anything, so this part here, you wouldn't be able to use this part here as like case law. It would be like persuasive authority. Just to be clear on the differences when you go beyond the affirm part, right? Because you'll see other things here that, oh my God, we can use this. Well, not really. Not in the same way as you could use what's up above in the main section, right? So keep in mind. So here we have a dissenting opinion. We're at our business to set the nation's social policy. I would agree with that hesitation that it is senseless for an enlightened society to deprive any children, including illegal aliens, of an elementary education. I fully agree that it would be folly and wrong to tolerate creation of a segment of society made up of illiterate persons, many having a limited or no command of our language. However, the Constitution does not constitute us as Platonic guardians, nor does it vest in this court the authority to strike down laws because they do not meet our standards of desirable social policy, wisdom, or common sense. We trespass on the assigned function of the political branches under our structure of limited and separated powers when we assume a policy-making role as the court does today. The court makes no attempt to disguise that it is acting to make up for Congress's lack of effective leadership in dealing with the serious national problems caused by the influx of uncountable millions of illegal aliens across our borders. The failure of enforcement of the immigration laws over more than a decade and the inherent difficulty and expense of sealing our vast borders have combined to create a grave socioeconomic dilemma. It is a dilemma that has not yet even been fully assessed, let alone addressed. However, it is not the function of the judiciary to provide, quote, effective leadership, end quote, simply because the political branches of government failed to do so. Wow, that's pretty powerful stuff, right? The court's holding today manifests the justly criticized judicial tendency to attempt speedy and wholesale formation of remedies, quote unquote, for the failures or simply the laggard pace of the political process of our system of government. The court employs, and in my view, abuses the 14th Amendment in an effort to become an omnipotent and omniscient problem solver. Yeah, I would. This dude's taking the words right out of my mouth, man. I feel the same way about this. Let me just look up omniscient real quick, make sure I have it. Omniscient. Knowing everything, yeah. Problem solver, that the motives for doing so are noble and compassionate does not alter the fact that the court distorts our constitutional function to make amends for the defaults of others. I have no quarrel with the conclusion that the Equal Protection Clause of the 14th Amendment applies to aliens who, after their illegal entry into this country, are indeed physically within the jurisdiction of a state. However, as the court concedes, this only begins the inquiry. The Equal Protection Clause does not mandate identical treatment of different categories of persons. So yeah, they're saying probably what you're thinking when you're watching this video of like, geez, this shouldn't apply to everyone under the sun, moon, and stars who come here, even if they're illegal. That's basically what they're saying here. Anyways, that's it. This proves that illegal aliens, quote unquote, have protection under the 14th Amendment, which is the same amendment that U.S. citizens have. So that's kind of what I wanted to show you guys. I thought that was pretty funny and pretty crazy because people are always wondering, why is it the illegal aliens get more stuff than they get treated better than even the U.S. citizens do? A lot of times they're not paying taxes, they're getting free shit, free phones, they're getting free rent, all this kind of stuff, right? So I wanted to do this video because I wanted to show you that U.S. citizens. Now keep in mind the day after slaughterhouse cases, we have Bidwell v. State, which is where Mr. Miller talks about how state citizens have no right to the 14th Amendment at all whatsoever. So keep in mind, state citizens are really the only class. So non-citizen nationals are a different class outside of the 14th Amendment. That's for American Samoans, Swain Islands, and I think the Northern Mariana Islands only. I could be wrong on that, but anyways, it's kind of irrelevant. Who cares? Because it's not really anything we need to even be talking about or dealing with. We have the Indian category, which is interesting. That's a whole nother situation. We have state citizens, and then everything else is kind of in that 14th Amendment category. So are U.S. citizens and quote unquote illegal aliens basically in the same bin? And the answer is yes. Because for the U.S. citizen category is the category that was created for the released Negro slaves. You even saw that on that one talking about the 14th Amendment, how they were talking about how it's for the free slaves. That's what it was for. So I don't know. I think that's interesting. I want to do a video on going through this and kind of looking it over. If you guys like this, let me know. If not so much, then I probably won't do a whole lot more of these. So just let me know what you think. And yeah, it's pretty fascinating. You can share this with your friends and stuff and kind of shock them half to death. But keep in mind, the courts they make these decisions based off of what's presented to them. So if the one side is shit and the other side shit, then you're going to get kind of like a shit product at the end, right? And keep in mind that anyone can come along and knock out these previous things. You can bring your own case and bring it to the appeals court and then bring it to the Supreme Court, and then it can knock out previous cases or situations or whatever. So just keep that in mind. None of this stuff is set in stone. It would just need to be, knocked out, or you would need to bring really good arguments to the table and to knock out these previous things. Okay. With that said, hope you guys enjoyed this. Let me know, and I'll see you later. Bye-bye.